Can you evict a tenant in 2021? With the recent CDC eviction moratorium being extended until June 30th, how can landlords legally remove tenants until then? This video is going to discuss 3 secrets we attorneys use to obtain evictions even in light of this extension. We'll also discuss the recent Texas Supreme Court emergency order, or the failure to renew that emergency order, and what that impact means for you. The CDC moratorium is the promulgation from a federal agency, Centers for Disease Control, and this was recently renewed by President Biden, and this only prevented landlords from basing their eviction on the non-payment of rent. What attorneys do is look for the exceptions that still allow you to obtain a writ, which is a writ of possession and a judgment, from the Justice of the Peace, who is the governing body in Texas. How do you get that writ from a JP despite this CDC extension that they may or may not choose to enforce? Number 1, holdover. This is a separate cause of action than non-payment of rent, and it is a valid exception under the CDC moratorium. And that basically means that when a tenant signs a lease, they start at month 1 and month 12, and once that lease is over, they don't have a right to occupy the premise regardless of the rent. And so we could evict a tenant either for A, non-payment of rent, which means you didn't pay rent, or B, your lease is over. The lease term is over. So regardless of the rent, we set that aside. Your lease term is over and we're evicting you for holding over. And I populate a lot of online forums, and there's some clever people out there that have talked about moving to month-to-month leases. And I think that's a great idea. It definitely works on its face for the positives. It gives more flexibility to the landlord to say, I can evict you even with a CDC moratorium because you do not have a right to occupy the premise because your lease is expired. I've given you that 30-day notice. I think that's a great idea. It's worked in the past and we've done it successfully with those terms. On the flip side, it requires you to be a very active landlord. You're going to have to extend their lease every 30 days, which is a lot of work. A lot of you that are watching this video became landlords because you didn't want to work. You want that passive income and you want longer term leases, 12, 24 months. And so that's one of the trade-offs, is that you become more active and you've got to keep extending the lease or putting automatic renewal terms in, and then you have to catch it if you want to evict them. So there's a lot of issues with switching to month-to-month leases. Now, the CDC moratorium also requires the tenant to provide a CDC declaration, but now the arbiter of its validity, whether the tenants are considered covered persons, falls to the landlord and maybe a local prosecutor. If you'll remember from the old CDC moratorium, there were no civil penalties for landlords who violated this, only criminal. And what that means is there is no slap on the wrist. There is no minor thing. You either have to blatantly violate, you have to have some intent to violate it, and they're going to go after you with criminal penalties, which means jail time. It means massive fines, not just a slap on the wrist. So when the penalties are very steep, they're going to have fewer, but obviously higher prosecutions of specific cases. And so I think that the risk to my clients when I'm advising them on this is to look at this on the face. Your penalties are pretty low. You either have to blatantly disregard it multiple times and face criminal, or you can probably make a good faith decision and know that you don't face civil penalties from a federal prosecutor for going after you who has got a couple rental houses in Dallas. So your decision, but just understand what those penalties are, and with civil penalties off the table, it becomes a all or nothing type of situation. Finally, that becomes a contract dispute between landlords and tenants. So to protect you, landlords should provide tenants a denial letter of why the tenant is not covered by the CARES Act. We're going to give you a sample. Drop your email below, sign up for our mailing list, and we'll go ahead and shoot you over a free copy of that document that you can use. Finally, we don't have to provide the CARES Act affidavits as part of our pleadings now that Texas is no longer under this rule. But landlords, if you own a property in the city of Dallas, you still have to comply with a local ordinance. And I cannot stress this enough, but it's really key not to listen to this video and just assume that what I'm talking about for residential properties in the city of Dallas, in the state of Texas, this doesn't necessarily apply to you if you're watching even in a neighboring city like Plano. Maybe you're in Fort Worth, maybe you're in Austin, Houston, Harris County. Every single county and city is enacting slightly different ordinances, and it's really complicated, and I won't sugarcoat it. It's hard for us to unpack and unravel what the current law is for your eviction. But at the end of the day, if you need your tenant evicted, contact us, schedule a free consultation. We'll take a look at your case, and we can often solve your case and get an eviction for one flat fee at the JP level. Under normal circumstances, let's talk about the timeline. The timeline under normal circumstances, day one, provide a notice to vacate. I think people are familiar with that. Again, we're happy to provide you with a free form. Day 4, you file that petition in JP court with the fees. Day 18, we typically have in Texas about 2 weeks where the JP will schedule a hearing. There are emails. It's pretty slick. It's a good system, and we get a hearing date in 2 weeks. Day 21, that's typically when they schedule it, is about a week, maybe 10 days now with COVID, but they were scheduling pretty promptly. And we'll get a default. We'll get a judgment. Even if the tenant shows up, we'll get a judgment awarded for the landlord. Day 27, we go back to the court to obtain a writ. That's what I talked about earlier, was the writ of possession. And we schedule the constable. We shoot that over to the sheriff, and we make arrangements for them to go to the property. We usually defer to their schedule, but we show up. Day 34, constables will usually post a 24-hour notice saying, again, that they're going to be coming back the next day, and they're going to forcibly remove any occupants from the property, but the sheriff does not remove any property, and that's a key distinction. They're there to keep the peace. They will remove occupants, which are people, whether they're on the lease or not. They could be squatters, whatever. But you, as the landlord, have the obligation to remove all that personal property in usually what is a fairly short window. The constable's not going to help, but he'll sit there and usually get a couple of hours where they're sitting there. So you want to bring enough manpower that they can clear out that property and put everything on the curb during that time that the constable's overseeing. You can change the locks, you can put your bars back on the door, whatever you need to do, but that is how you do an eviction. And that whole process from start to finish in the great state of Texas was taking about 35 days. That is an incredibly quick process compared to some of my colleagues in California, New York, Oregon, Washington State. A lot more tenant protections, a lot more procedural hurdles, and it takes much, much longer to get a non-paying tenant out. So that's it from me. If you need to evict someone, please put your email in the link below. We'll send you free forms, everything you need to know. That second tip too was evidence of criminal activities. And I get a lot of questions about this. What does it mean? And we've successfully done it. And really what you just have to do is put together a little mini brief. You put together a legal case that says we have photographic evidence of X. We have the police being called for Y. We have arrests occurring at the property before. Maybe you have testimony from witnesses. Whatever facts that you as a landlord have caused you to believe there are criminal activities. Do you need an arrest of the tenant? No. Do you need a conviction of the tenant? No. Do you need 911 to be called? No. You just have a burden, and it's a pretty low threshold. It's not like we're throwing them in jail. We're not accusing them of a specific crime. But if you have evidence of criminal activities, we present all this evidence, and hopefully, if things are in writing, testimony, photos, videos are great. Everybody has a Ring or some kind of security camera recording. Put all of those together, and we'll assemble a package to present to the judge and say, Judge, this really looks like criminal activity. We've got 17 people who drive up, and the tenant comes out, walks to their door. There's a little conversation, exchange happening, and he goes back into the house. This is the number of occurrences we have. Here are some photos. Here are some video. We strongly suspect criminal activity. That's all you need. And so we put those together, and that's the other two secret exception to getting around the CDC moratorium. All right, guys, tip number 3 from lawyers who win evictions in the CDC era is to challenge the CDC declaration itself. Now, on its face, it seems like the tenant can just fill out this form, and there are a lot of subjective requirements and they just sign it and submit it to the court. However, we have had success where we have specific evidence refuting each one of those points, and all we need is a little bit of evidence to prove that one of those statements is not true, and then they won't fall under the protection of that CDC declaration. So that's it. That's the 3 secrets for lawyers challenging evictions. I hope this is useful, and for your next eviction, if you have a complex one, this can help you navigate the CDC era if you don't have some of these other alternatives available. That said, those are difficult cases and not straightforward, not for the faint of heart. But if you want to hire a professional, contact us for a free consultation. I have the link here. Thanks for watching, and see you next time.